Okay. Good afternoon, everybody. Thank you very much for being here. It is a tradition of the LER Festival that the Italian Antitrust Association organizes the opening session of the festival, and we've done it in the last few years. This time we have changed though, and we have organized the closing session of an incredibly successful event. And as usual, every other time we open our session, I make the best compliments to Paolo and the other people there for what they have been able to do and to achieve. This year, for what Paolo tells me, I'm sure it is true, there are more than 350 people here coming from all around Europe and the world. So I think it's a great achievement for LER, obviously, but also for Italian antitrust community, which we represent, because it means that it's a very lively activity that they are going to do. Now, the subject of today's roundtable is the status of the more economic approach. This is time to take stock of the more economic approach. Now, this is not the first time that we discussed this issue, because already 3 years ago, we organized the opening session at the time is the more economic approach in good health, and Pinar Akmar, Antonio Butta, Giorgio Monti, and Alberto Toffoletto exchange opinion. And at the end, we had a substantially subdued verdict of optimism about what was going on. Now, as you know better than me, the discussion on the more economic approach started since the moment the more economic approach was adopted, say, around 2004 with the modernization regulation and the review in the application article 101 and therefore the rule of reason. And it has also put in contrast, say, the court and the commission and the practitioners. Over time, the court seems to have been moving toward a better understanding and sharing the idea of the more economic approach, but the other side has instead started having second thoughts. For reasons which go economic analysis pointing to too much concentration, too much inequality, so this means that antitrust is not doing its work, and because of developments of the digital economy, which obviously poses different issues in terms of enforcement. This was already reflected in the discussion a few years back. It is even more even now, also because of developments we see, for instance, the proposal for new guidelines on Article 102, which seem to have a more formalistic approach with respect to the criteria suggested by the more economic approach, and by, for instance, DMA in relation to the digital world. So we think it's an appropriate subject to discuss today. And to discuss this, we have a really distinguished panel. We have, first of all, Jorge Padilla, who is is an historical monument of, and that's why he's first, of economics of antitrust. I think we met, I don't know how many decades ago, but it has been a great honor to work with him and to discuss with him. He's currently a Compass Lexicon, but he had a previous experience as leader of other activities. Then we have Maria Teresa Maggiolino, who is...
Not historical.
Not historical. Well, but she is making a path in the antitrust world. She is a professor of competition law at Bocconi, and she's, I would say, one of the most active academics in this field, always. Then we have Mario Siragusa, that is also historical. There's a lot of historical people here. And okay, so let's and then we have instead who is, well, I don't have to say anything about Mario Siragusa, and then we have Tommaso Valletti, who is as in the history of of European competition antitrust as former chief economist of DG Comp, and presently is in the Imperial College. All these historical people do not have necessarily the same ideas. We'll proceed, so I think we'll have an exchange of views, which will be open to intervention or questions after their interventions. I may have my own idea, but I won't tell them until the end. So we start with Jorge Padilla, then Tommaso Valletti, then Mario Siragusa, and then Maria Teresa Maggiolino. About 8-10 minutes each. Jorge, you have the floor.
Thank you so much. Thank you so much, and in particular, thank you, Paolo, for this invitation and for bringing me here. I'm really pleased to be with all of you. So yes, I guess that I'm historical in the sense that I can go back to 2004. In fact, I can go back a little bit before that and do a before and after and think about and tell you why, what motivated the change at the time. And interestingly, I think that the reasons behind the adoption or the increased adoption of economics at the time were different depending on what type of antitrust instrument you look at. So I think that at that time, by 2004, everybody was persuaded at the Commission and outside the Commission that economics was very relevant in the context of agreements, and in particular in the context of vertical agreements, and there was very little dispute about that. At that time, there was a concern that perhaps merger control exhibited a significant gap, and as a result of that, could have led to under-enforcement. We had the dominance test, and that was replaced by the SIEC test, and the idea was actually to fill a gap, to fill the so-called oligopoly gap, situations of mergers that produce unilateral effects, but that don't result in the creation of a dominant position. And so from the perspective of merger control, the adoption of the more economic approach was more an attempt to correct problems of under-enforcement. But if you look at the issue from the lens of Article 102, the idea or the discussion at the time was somewhat different. I think that there were lots of voices following, in particular, decisions by the European Commission in the Michelin case or in the British Airways Virgin case, thinking that perhaps in the context of Article 102 enforcement, what we had was an over-enforcement problem, not an under-enforcement problem, and that the reason for that is because the legal rules in place were, well, per se, or almost per se, rules, and that if we moved in the direction of adopting some form of rule of reason or a structured rule of reason, increasing the relevance of economics, we would be able to correct that under-enforcement problem. In this context, which is the one in which I'm going to focus on from the Article 102 perspective, the contribution of economics, or the more economics approach, was to place emphasis on consumer welfare, the consumer welfare standard, and to place emphasis on effects, not on actual effects, but on the need to show likely effects. I don't think that at the time we had anticipated that so many rivers of ink would be spent discussing actual versus likely versus capable versus possibly likely, somewhat likely, a little bit more or less likely. So we had not anticipated that. So to some extent, I think that the process that led to the guidance, which was a very slow process since 2004, with a draft in 2005 and eventually culminating at the end of that decade, was an attempt to introduce these two notions in Article 102 enforcement at the European level. That intervention was warranted when there was harm to consumers, and that the Commission had to show not only a hypothetical concern, but it had to present evidence of likely effects. That there was a fundamental difference between foreclosure and anti-competitive foreclosure, and that the, in a sense, realm of the scope for per se rules had to be much more limited. And since then, well, there have been, there has been lots of discussion back and forth. The court sometimes has been, more reluctant to adopt those ideas. It appears that more recently has been somewhat more open-minded to those ideas. And if we look at Servizio Elettrico Nazionale, I think that, in my opinion, it adopts the more economic approach in the right way. But the use of economics and this economic approach, this emphasis on consumer welfare and likely effects, has been the subject of criticism largely because one has the feeling that it has resulted in under-enforcement, in particular in the context of digital markets. And I think that there is, quite a general view that, if anything, cases now take a lot of time, that the emphasis of the legal test may be to anti-intervention, and that as a result of that, we have seen market power entrenched and consolidated in industries that at one point would be much more contestable than they have proved to be. So there is a general feeling that the more economics approach has perhaps overshot, and as a result of that, we have under-enforcement. Now, the more economic approach is criticized more broadly, and is not, the criticisms are not restricted exclusively to digital markets. I think that there is a sense, and perhaps even more in the US than in Europe, that antitrust enforcement has failed very severely, and as a result of that, there have been, or we face significant macroeconomic problems, increasing concentration in the economy, increasing markets, increasing inequality, reductions in investment. And it's important to note that this debate originated in the US, where antitrust enforcement has been clearly much less significant than in Europe, in digital markets and non-digital markets. The macroeconomic evidence is somewhat complicated. I'm not a macroeconomist, so I'm not the person to adjudicate. There are many authors insisting on those problems, and many authors insisting in the opposite direction. There are methodological debates. There are debates as to whether or not indeed the increasing concentration is that significant, in particular in European markets. I know that Tommaso has been doing some work himself, but there is a controversy, and I will leave it there. I'm not going to adjudicate who's more right or who's more wrong. I think that there is some controversy in that respect. But the controversy, where the controversy I think is more significant, is whether you attribute those macroeconomic developments, adverse macroeconomic developments, to the lack of antitrust enforcement, or to other forces, or to a combination of forces. And of course, what we see is that there are many things that have been happening since 2004 in the economy, leaving aside the Great Recession of 2008. More recently, you can see the penetration of technology, the intensification of technology in the production processes, in some places like the US, but also in Europe, the decline of union activity, the shift from non-digital to the disruption introduced by digital companies in many sectors, the fact that technology seems to diffuse to a lesser extent. So my view is that at this point in time, what you see fundamentally is more a debate about feelings than something where the evidence is clear-cut and can adjudicate whether we need a serious reform or we don't need a serious reform. I think that, in my opinion, the jury is out as to whether indeed there is a problem of under-enforcement, whether the more economic approach has overshot the initial over-enforcement concerns or not. But if you talk to competition agencies, I think that they have a clear view that there is an under-enforcement problem. And what I've been trying to do recently is to try to understand why do they believe that there is an under-enforcement problem. And of course, the easy explanation always is to have a conspiracy theory. Somebody is paying them to think for the way that they think, and that may be with actual money capture, or maybe because they are expecting the revolving door to operate in a particular way, and so they want to be nice to industry. But frankly speaking, I think that that's not the right explanation. I wouldn't be able to give you lots of theoretical papers, but I live I live in the same home that the president of the Spanish Competition Authority, and I can see how she operates, and I don't think that she is captured in that sense. However, she's pessimistic, and she thinks that there is some under-enforcement, and it's interesting because she used to think the opposite when she was in the private sector. Now, you may say that in the private sector, people think that there is not an under-enforcement problem because they are paid, and maybe that's more true than in the case of the competition agencies, or also we have motivated beliefs. But I think that competition agencies have chosen to be pessimistic. Now, notice what I'm saying. I'm saying that they choose what they believe. And I think that for many years, that would have been, this statement would have been immediately criticized by economists saying beliefs are not chosen, beliefs are, you have your beliefs, period. Nowadays, thanks to the work of Nobel Prize winning laureate Jean Tirole and many others, Roland Bellabou and others, we have adapted the psychology of our economic models to think that people also have preferences over beliefs, and they choose their beliefs. And people choose their beliefs for different reasons, sometimes for purely deontological reasons, sometimes for self-image, sometimes as a result of peer pressure, and so on. So motivated reasoning is one of the factors that I think explain the difference in views between competition agencies and the private sector about the extent of under-enforcement. Now, what I have done in a very recent paper is to try to understand two things. First, what kind of, whether it is optimal for regulators to choose pessimistic beliefs about the likelihood of anti-competitive action, that is, to overestimate infringement and to underestimate compliance, whether it is rational for them, under which circumstances, which type of regulators would choose those pessimistic beliefs, and whether it is really bad for society that they are pessimistic or not. And to cut the story short, what I find is that there are many types of regulators for whom it would be optimal to choose pessimistic beliefs, to think that there is more infringement than there is, to believe in under-enforcement, including, interestingly, those that maximize consumer welfare or total welfare. And because of that, the interesting conclusion is that you need to be careful in debiasing those regulators. You may be concerned that they are too pessimistic, and in fact, if you are a compliant firm and you end up being found infringing when you were not infringing, you would always be very angry and concerned. You would prefer more decision accuracy. But given that it is easy to make errors in the two directions, and given the incentives of the players in the marketplace, actually having a system that in a sense overshoots in terms of infringement is good from a consumer welfare perspective and a total welfare perspective. So let's be careful with the biasing. Now, it seems to me then that the question is not whether we transform the competition agencies in realists or in optimists. We want them to be somewhat pessimists, is a degree of how pessimist they have to be. And I think that the last part of that paper, what it says is that I hope that they are more hopeful pessimists. Hopeful pessimism is an idea advocated by a number of philosophers, including Mara, I wouldn't be able to pronounce her surname, but you can see it's Van der something. And the idea is be pessimist, but be open to be criticized, and be open to change your mind. Be pessimist, but not be skeptical, but not be close to interaction. And that's very important because the problem with motivated choices, motivated beliefs, is not only that you choose to be pessimist, is that oftentimes you become skeptical and reluctant to reassess the evidence. And you develop stereotypes. You know, everybody that disagrees with me is corrupt. Everybody that agrees with me is great. I'm not going to attend conferences with people that disagree with me. I'm only going to speak to people that agree with me. I'm going to exclude these guys because I don't want to hear them. That is the problem. The problem is not pessimism, is stereotypical thinking, and is defensiveness. Hopeful pessimism is a way of being pessimist, but open to criticism. And I think that that's where we have to be. And I believe largely that that's where the Commission wants to be, and that's why it has produced a consultation and is looking at you know, what people say about the guidelines, etc. But what we want our regulators, therefore, if you agree with the context of my analysis, and there are a number of assumptions behind which can be criticized, is we want them to be a little bit pessimist, better than to be pessimist than optimist. In fact, it would be on the private sector to be the optimist. We will bring them the stories about why things are not bad, but we want them to be open-minded. And definitely what we want to avoid is cancellation. And I'm saying this because I think that the Commission is in the right direction, but I think that the danger of cancellation and stereotypical thinking is there. Look, it's all over the place. It's not just in our world, the idea of polarization, and that's where my concern lies at the moment. So let me stop here.
Thank you very much, Jorge. It's very interesting. I was at the Italian authority for some times, and I always thought that the system of incentives within the authority was such that you would be pessimistic, in the sense that nobody, at the end of the year when you are evaluated, and if you have done a number of cases and you said, well, there's really nothing. This vertical agreement is really efficiency enhancing, and really this abuse is not an abuse, you probably won't be evaluated as well as you would be if you are working on a very big case, or case which is considered as such. So there is a sort of incentive, and that's why I think that, say, the internal organization and the system of check and balances within the organization is very important, as it is in designing guidelines and so on, the discussion, and appreciating also what comes from outside. Okay, Tommaso has been chief economist at DG Comp, and before getting to the Imperial College and after having been an economist here in Rome, he has been, since he left the DG Comp, a vocal critic of the prevailing attitudes in enforcement guided by the more economic approach. So the floor is yours.
Thank you, Alberto. Thank you, Paolo and to Leah for this amazing festival. It's also challenging to be called historical in a place like Rome, because this can mean a lot of things, but I take the positive. I just want to say that my personal journey is a bit different. So I'm an academic. I've been studying academic stuff, but always with a policy interest for 25 years. At some stage, I had the opportunity, which was a great opportunity, to do policy. That's when I went to Brussels. For a couple of years, then I still participated in an active way to the policy debate, but then, personal choice, I decided to drift away from that and go back to my academic work. So there are advantages and disadvantages. The disadvantages is that I cannot claim to be as competent as these amazing practitioners, amazing legal experts. I'm not. So I'll say up front, I don't have the nitty-gritty. The advantage, perhaps, is that since I'm a bit away from that. I have a bigger picture. These are my views. That's, I guess, also why I'm invited in a place like this, and I have no skin in the game. No skin in the game. I don't do consulting, so I disclose. I have nothing to disclose. So, and how do I see this? And I'm just telling you my personal opinions in the most genuine way. And the way I see this, and sorry to be, despite this amazing festival for 3 days, to be like a party poopers, I don't think we are in a great place. Big picture. So I see the European project at risk. There's lots of uncertainty. There is lots of risks out there. I don't see the industrial fabric of many European industries in a very healthy state. I don't see our social fabric in a very healthy state. And if I go across the Atlantic, and this is specific perhaps even to our topic today, which is antitrust and competition policy, there is overt corruption going on. I mean, if you are familiar with the HP-Juniper merger out there, that was sheer corruption going on. And we cannot always claim that we are different, we are insulated from those forces, because I think this would be a bit complacent. We in this room, great guys, lots of friends, but we're not representative, I think, of the world out there. So I think it's fair, especially 20 years after the adoption of the more economic approach, which, by the way, did not come because of market forces. It's a project that started in the United States earlier on, but it's because the court told the European Commission, you must do more economic approach, because the Commission lost a lot of cases. You must do it. There was no way out. We used it for 20 years, and I think, have we achieved a lot? I don't know. I don't think we have achieved a lot. And this happened at a historical junction where there was agreement about what to do with small changes at the margin, what is this thing, that thing, etc. But in a sense, the intellectual basis was generally agreed by most of the players. So have we done a good job? Again, observing a little bit from further apart, I see a lot of bottlenecks in our economies. It is, of course, in digital. Think about search, media, ecosystems, semiconductors, the cloud, but also elsewhere. If I have to think about big pharma, solar panels, gas and energy, shipping, medical devices, agrochemical, payment systems, supermarkets in some countries, banks in some countries. So there's a lot of them. There's a lot of them. So it's not just the emphasis on digital. The way I see the data, I don't know if I differ from other panelists, is that sometimes the data are shown by comparing apples and pears. You really need to look at the distribution of the big corporations, so the top side of the size firm distribution, and data are quite unequivocal if you look at that, because there is lots of firms which are straggling, of course, but they are not at the top. They are below the average for sure. We got there in different ways, including the use of economics. And here, I'm not criticizing economics as a discipline as such. I've devoted 25 years of my life to the study of it, so that would be a complete failure. When economics gets into policy, there are some interesting processes which are going on. And interesting is perhaps downplaying what I really mean. There is a guy called Leonard Seabrook. He's a comparative political economist who have coined the term epistemic arbitrage. Okay? I don't want to go into academic stuff. By the way, it's funny, I am an academic. When I come back to policy, I don't want to bring academic. It's very pragmatic what we have to do. It's very practical. But what is this epistemic arbitrage? It's basically moving theories between academic and courtrooms, done by interested parties, not by the academic themselves, by interested parties. It's not a neutral transfer of knowledge. So let's go away from the theory, let's give you practical examples. So some examples which are really interesting to me are, for instance, the theory of contestable markets. I'm sure you must have heard about it. How many people in the room have heard about contestable markets in the room? Yeah, quite a good number, great. So this is a theory which has been abandoned academically since the mid-80s, because it's a theory which is not robust. You just introduce a small and some fixed cost, and it falls apart. There is not a single academic paper published in the top 20 journals in economics in the past 25 years on contestable markets, because it was not robust. Abandoned, let's move on, let's do something else. However, this contestable market theory, you know about it, has had an incredible impact on policy. All the deregulation movements in the 80s and beyond, okay? Even with digital platforms, we still refer to that. So there is something which is discredited, abandoned academically, which is still influencing policy. Another example, let's come even closer to your turf, mergers. If you look at what the theory of mergers say, in the absence of efficiency, I'm not moderating words here, every merger is bad for consumers. Every horizontal merger is bad. Did you know about that result? Wow, this is not possible. Now, we are challenging only mergers to monopoly. That's the only thing which has remained, actually, in the practitioners' understanding of that. There is not such a... Instead, the theory would say every horizontal merger, we lost it, okay? Of course, we can bring in efficiencies and flip the result around, but that's what the result says. Vertical mergers, I'm sure you heard that there is a presumption from economics that vertical mergers are efficient. There is none such a presumption coming from the theory. There is a trade-off. Okay? There may be some internalization of stuff, but there is also foreclosure, but there is no presumption whatsoever. So you see, this is epistemic arbitrage, something that comes to you, which was not coming from us, the academics, but it got to you. So this is what we learned. We also, and this I can relate what I've been doing in the past few years, a feeling we had that big corporations have the power to influence policy, which was the foundation, actually, of the antitrust movement in the late 19th century. Louis Brandeis and these people were not concerned that concentration would raise prices by 2%, 3%, which is what we do in practice. But they were concerned that concentration would be bad for democracy, which is a concept that, again, to the lay person makes a lot of sense. But we don't know. Now we have the data. I've been analyzing every single merger, not just those which are subject to antitrust vetting. Every merger in the United States for 20 years, linking those mergers to lobbying expenditures, because the US has this advantage of allowing any sort of money transfers, especially after Citizen United. And we found that mergers were causing an increase in lobbying spending in the United States of $3 billion per year for the past 20 years. So as a lower bound, we got $60 billion. A lot, a little, we can debate, but this is evidence. There is also evidence that this is not good for democracy. And what do I mean by this evidence? This amazing research done by colleagues at the University of Cambridge that correlate increasing margins at the top, because this is where it is coming. In my research, I see that this lobbying comes from the large corporation. The average guy doesn't do it. They don't have the resources. They don't have the market power. So the markups of the top firms worldwide are responsible, and I cite, of 1/4 of the observed decline in global democracy. Directly can be attributed to that. And in the United States, this share increases to 40%. A decline in democracy is directly attributed to the increasing margins of the large corporation. These are big things. These are very big things. So what can we do? What can we do? There are typically three responses. One is basically exploit uncertainty. There is a term called agnotology. I love sometimes, my wife is Greek. So agnotology is the ignorance in deliberately producing, ignorance deliberately produced by corporate funding. The biggest case were the big tobaccos. Already in the 50s, they knew that smoking was not good for our health. Smoking was causing cancer. However, they said, well, there's lots of reasons that can cause cancer. Okay, this delayed our understanding of about 30 years of the linkage because they were funding universities, big universities, to study the correlation between cancer and something else, okay? Air conditioning systems, that was done in the 60s and so forth. So we can adopt that, so agnotology, such exploiting uncertainty, keep doing the same, small adjustments at the margin. Since I think overall the picture is not healthy, I don't think this is the right direction. Secondly, this is a different approach coming more from the enforcers. I don't have anyone in mind, but somehow there has been a self-fulfilling prophecy out there among enforcers. They say, yes, Tommaso, we think there is a bigger problem. Yes, we see that. It's tangible. We can sense it. Apologies, but there's nothing we can do. It's not us. It's not us. Competition is a side dish. No? How many times have you heard of that and repeated over many times? We would love to, but we cannot. This produces the same outcome, a self-fulfilling process. By the way, in Brussels, and that's my perception, competition policy is sidelined. So all the discussion is happening elsewhere. With trade, with industrial policy, competition policy is sidelined. So again, different perspective, but same outcome. We will end up doing a little bit of the same, and where do we improve our societies? Do we improve? The third and last, and I will stop, which is obviously what I've been trying to do as a voice. I mean, you may disagree with me, but my job as an academic is also to let you think. I have any truth. I just tell you my honest views, and I would like you to think about this bigger picture. And my view is that in our economies, we need a massive injection of competition, a massive injection of experimentation. So whatever it takes to get there is the most welcome thing. Is it more of the more economic approach? If interpreted the way we have done until now, no. That kind of economics is not going to lead us to this massive injection of competition, is not going to lead us to experimentation. It's going to just continue this path towards insignificance. And again, sorry for being doom and gloom. I love this conference, and so I'm still grateful, and my smile is back. But I'm done with the negative aspect. Thank you very much.
So we were looking for somebody with a pessimistic approach, and I mean, we found it. I'm not sure that what you found by examining the mergers in the US and the waste of resources, you would find in the EU practice of merger control, but I mean, is a reasonable doubt. As for the role of economics, well, the regulation of the airline business was based on Baumol contestable markets view, and in a sense it was also the regulation in Europe. Now, surely following analysis have showed the limits, and doubtlessly this is true, but now we go to Mario Siragusa, and then we'll have further discussion.
Thank you, Alberto. So, I have not read your article in which you try to be a psychoanalyst to antitrust enforcers, but I read the other article, which I found extremely interesting, the one in which you make the list of all the pro and contra claims made on the most economic approach, and illustrating the criticism made and how to respond to those criticisms. I found that extremely interesting, so I went through all those claims, and I focused on some of them, because many of them I found them due to the fact that economists, like sometimes also lawyers, tend to take themselves too seriously, right? I don't think they have this overwhelming power over competition enforcers. But there are some of the claims which I found very interesting. For instance, above what among what you call the ideological bias, you say that two criticisms are often made, which say that the more economic approach has led to under-enforcement, and I quote from your article, because economists focus excessively on consumer welfare and ignore fairness, equity considerations, rivalry, and so on, and because they focus excessively on efficiency, okay? I think those claims are very important because, of course, they go to the question at what is the object of competition law, right? Exactly that, right? What is the object of competition law? Now, I think that indeed there are several, but more than economists, I think regulators, politicians, who say that pursuing consumer welfare is too limiting, right? Limits the enforcement of the competition law, ignores those considerations like equity, sustainability, fairness, and all that. And then, of course, this concept of economic welfare, of consumer welfare, which it is an economic concept, right, has become more economically oriented with the more economic approach, right? But I think that it's precisely the strength of this objective and its economic nature which has had some very positive effects on the enforcement of antitrust rules. And what are those effects? First of all, it has given credibility to the system because it has imposed, strict standards of evidence based on economic analysis, first of all. Secondly, it has created, through the case law, a certain level of legal certainty, which I think has been extremely important in the history of antitrust enforcement in Europe, particularly if you think about the transition from what was the original type of enforcement, which was very much form-based, to one which was effect-based. So you needed a sort of discipline of having an economic review in order to assure some form of legal certainty. And most important of all, I think the consumer welfare approach is a shield against influences by politicians and by lobbyists on antitrust enforcer. Could you imagine what would have developed, what would have happened if we had, what could happen if we have all these other variety of principles of fairness, equity, all the way industrial policy, employment protection, social policies, if all that gets injected in the antitrust enforcement, I think antitrust authority will become absolutely the prey of lobbyists and politicians which are going to influence their decisions. So I think that for me, the consumer welfare is a shield, is a very important shield, which is particularly important, I think, in Europe. Also because some of the criticism may apply in the US, but certainly do not apply in Europe. In the US, certainly the consumer welfare concept has been applied through an extreme efficiency-based approach, right, which has substantially reduced the scope of antitrust enforcement, limiting it to cases which had an impact on consumer prices, right, on prices. But that's not certainly what has happened in Europe. I think that criticism is absolutely not what has happened in Europe, where the consumer welfare has always been interpreted in a much more balanced way, in which the protection of a system of competition has always been recognized by the case law of the court, certainly. So it has not been oriented exclusively on efficiency. And by the way, everybody who practices a bit in this area knows how difficult it is to get efficiency recognized by the Commission and by the Antitrust Authority. Please, don't tell me that our enforcement is based on the recognition of efficiency. It's extremely difficult to convince, antitrust authorities in Europe that the benefit of a merger, for instance, because of more efficiency, should become, predominant. So, you also analyze some other form of claims which have been made. For instance, the fact that complex analysis models may make it more difficult, too many complex mathematical models. Have you ever seen a judge which is going really to consider an economist model too complicated with an average intelligent man cannot understand? I never saw anything like that. A judge will put that model aside and will not give any weight to such a model. My economists have to be clear, have to be simple, otherwise I don't need an economist. The economist has to be very clear, very convincing, very fact-based, and very simple and very understandable. Otherwise, I don't need an economist. That's absolutely clear. Has it increased the cost of enforcement and does not produce robust result? But what in life produces robust results? What in life produces robust results? Do you think that the legal analysis is always extremely robust? Do you think that the case law cannot be interpreted in different ways? Of course it can. So I don't see this difference between economic analysis and legal analysis. You have exactly the same problem in one and the other. Finally, You analyze claims that the use of the most economic approach has had a bad influence on the legal standards which have been applied, right, the rule of reason. But let's since you are in historical, and we are all here historical, let's look at history. Let's look at history. But you remember how was the enforcement of antitrust law in Europe in its initial stage, and for many, many years. It was based exclusively on a form-based approach. You remember, any contractual restriction was per se a violation of Article 101. That was the starting point. The German doctrine was absolutely on that. Any restriction of the contractual freedom was a violation of 101, which you could consider under 101.3. You forgot all that, not? Economists don't know the law, that's the problem, and forget about where we come from, right? It has been the lawyers, it has been the Court of Justice, and you recognize that. It has been the Court of Justice which has obliged to develop an economic analysis, and that this has been extremely important in order to, again, not have an exclusively form-based approach and try to go to a system which has a serious economic analysis at the basis of any decision which enforcers have to make. So I think that's also extremely important. What do you want to do? Do you want to go back to a form-based approach? That's what you want? Okay? Certainly, I don't think this is the future. And the future, I think you do say that, is maybe the development of these rebuttable presumptions, but those rebuttable presumptions have to be based on some economic ground. Otherwise, it's all, discretionary, and it's only, as I say, prey of lobbyists and politicians, which is what we want to avoid. Increases the cost of the procedures. Yes, they may increase the cost of procedure, but very often the increase of the cost is not due by the parties, it's due also by the enforcing authority. You remember what happened in Intel. In Intel, the Commission wanted to make, the as efficient competition test analysis, even if it was not necessary. And they say in the decision that it was not necessary. Of course, the court then said, well, wait a moment. If you have made that analysis, you should also and take into account, the arguments of the other parties against that analysis. So that's, of course, logical. And you see that also in our Italian case, in the Unilever, the Italian case which went all the way to the court, you have the same approach. There was an economic study which was submitted and which was ignored by the AGCM, and of course the court says, no, you should at least justify why you have not taken into account the economic study that is submitted. So I don't think that necessarily you have to have this increased cost or this complication in the So that's what I have thought in reading your article. But now, in reacting to what you said here today, I have two things to say, one for you and one for Tommaso. For you, I say, if you think about it, I like this thing of your psychoanalysis, but I think the European system is based on this pessimistic approach. Why? Because it gives all the power to the antitrust enforcer, right? Either the Commission or our authority. They have the power to investigate, they have the power to decide, they have the power to fine. So by definition, they have a pessimistic approach, right? Because they think there must be a violation. I want to punish it, right? So the system is based on that equilibrium. Authorities are pessimistic. They believe that the world is made of wolves and you need to intervene. And then there is the court, which, thanks God, right, then reestablishes a certain equilibrium. So I think maybe, your idea is not so bad. Yes. But Tommaso, of course, any merger has a negative effect by definition because it reduces, there is one competitor less, right? So when you say, we scientists, we say that any merger has a negative effect, okay, if you think about a perfect competition system, any merger reduces by one the number of competitors. But again, do you need something, a standard? What has to be the standard? Okay, but this reduction of competition, is it substantial? Is it important? Does it really produce harm? Yes or no? I don't think we can say all mergers are negative. All mergers are negative from a theoretical standpoint, but as an enforcer, you must have some guideline on how to say yes or no, right? And what can be this outline if not an analysis of the actual potential effects? I don't see what other analysis you can make in order to discriminate between the merger which can be authorized and the merger which cannot be authorized. You may say that the standard of merger review, which has been applied in Europe, has been not very strict. I've been saying that for years and years. I've been saying that in Berlin. I've been saying that everywhere. Okay, but that's, you can modify, but that's not a problem. That doesn't mean that you don't need an economic review, an economic standard, in order to decide when to intervene or not. And with that, I stop. Thank you.
What a real show for the end of the Real Festival. I had one point, but I won't tell it. I let it go later. Now, let's Maria Teresa say.
Okay, thank you. Now, obviously, I came here with a speech, but now that I've heard all these opinions, I have to jump in and tell what I think about what they say. But I would get started from one point, what I tell to my students when I'm in class, because I'm a teacher, okay? And I use a lot of economics in my classes. And my students are law students, and they ask me, why? Because they don't like it. And I say, well, because whatever is the evil that you want to eradicate from markets, before doing it, you must know how markets work, how firms behave, how consumers take their decisions, and in order to design a good remedy, a remedy which is not worse than the evil that you want to eradicate, you must know economics. And so what I teach to my students, and probably I am a bad teacher for this, is that economics has a through-bearing capacity that I recognize. Economics can help us understanding how the world works. And in particular, in my opinion, it is able to dispel some commonplaces that we frequently read on newspaper, for example. Think about the debate about the price, the wages, the price of inputs and outputs. There are often headlines that say that consumers can afford the cheap goods because workers are not paid well. But we know that if there is monopsonies, if there are monopsonies, also output is restricted, and so prices are higher than how they could be. And so there is no real and no often the clash that the newspapers talk about when we analyze the interaction between input and output market. And this is a takeaway that comes from economics. It's not a takeaway that comes from policy or political debates. But once I say so, I go to what Tommaso was saying. He's right when he talks about the epistemic arbitrage that we do in courts. On the one hand, the good thing is that at least we try to speak with judges and we use economics as a common jargon and a bridge to try to put everybody on the same ground. But it's true, we may side with a theory or with another theory. And the point is that I don't think that economics is always for under-enforcement. Think about our notion of barriers to entry. It goes back to Joe Bain, to the structuralist approach. It has not endorsed the approach of Stigler, which would be much more lenient toward incumbents. Think about the theory of harm that we have endorsed in Microsoft. That's a post-Chicagoan theory of harm that has nothing to do with the single monopoly theory of Chicago. So the idea is, it's true, there are some economic theories that do support under-enforcement, but we are not obliged to endorse them. And over time, antitrust authorities have looked for better theories that could be more accurate in explaining how markets work. I've wrote about the digital mergers scrutinized by the EU Commission. And as Jorge was saying, one of the reasons why we had lower enforcement or law enforcement in the digital world is also for reasons out of economics that do not depend on economics. Things about the thresholds. We didn't scrutinize many mergers because they did not overcome our EU threshold. But still, those that were scrutinized by the EU Commission, if you go through them, you will see that our Commission has changed the conceptualization of the consumer. In 2012, when it analyzed the Google-Motorola mobility merger, the Commission endorsed the theory of the rational consumer. So it said that consumers would have switched from Google to any other application because they were rational enough, savvy enough to look for them. And then in 2014, in WhatsApp, Facebook merger, in the Google Android case in 2018, the Commission did endorse the status quo bias. And now in Booking a Travel, he made the case around consumer inertia. So the Commission has changed its conceptualization of consumer, moving from a neoclassic conceptualization of consumers as Olympic agents to a behavioral economics conceptualization of consumers. So I would say this, that if you read economics and if you study economics, you may slip into ideology, Chicagoan ideology, say blind faith in economics. But you are not supposed to do that. You can always look for facts and trying to see if the theory you are using is accurate in explaining the facts at hand. But this, unfortunately, this focus on fact-checking brings us to what is, I think, the real problem with today more economic approach, which is administratability. And I'm thinking about the Intel saga. Applying the as efficient rival test takes a lot of time, takes a lot of resources. And make that kind of analysis in every abuse of dominance case, at least regarding pricing practices, would cost a lot of resources to agencies such as the EU Commission, but it could be the same for every authority around the world, that have just a limited number of people working on them, on the cases. So I think that our real challenge is not trashing out economics, as somebody would like to do, nobody here, fortunately, but finding legal tools, procedural tools, to make trials or proceedings last shorter, being shorter, and from distributing the burden of proof. Because otherwise, we run the risk that going after the details of the specific case, we, how can I say, we lose the focus of the case and we lose the opportunity to prohibit or to save one conduct. But, and then I will conclude, this is nothing true. If you go and read the dissenting opinion in Liggin, what Justice Breyer said, speaking about the change from the per se rule of Dr. Miles to the rule of reason that they adopted in Liggin, Justice Breyer was for the dissenting. He said, economists suggest sometimes, he said, many economists suggest sometimes resale price maintenance can prove harmful, sometimes it can bring benefits. So he stressed a lot these conflicts among theories. But before going one hand or the other hand, you must ask yourself two questions. How often are harms or benefits likely to occur? So facts checking. We need presumption that help us understanding what is the default rule and what should be proved in every case. And then we wrote how easy is to separate the beneficial sheep from the antitrust goats. And this is the point. If we become too sophisticated, probably we could have longer or too long proceedings that, or too expensive proceedings that actually give us the feeling of under-enforcement. Thank you.
Thank you very much, Teresa. I will now open the floor for questions or observation. Okay, please. We need a micro. Oh, hello. So if he has to leave before your observation, since we had all 4 discussions, please, Tommaso, tell your opinion at the end of this first round.
Oh, great. So just an opportunity to apologize if you see me rushing away. It's not because I'm furious, I'm dissenting, which I am, of course, but I have a plane to catch. Apologies for that. So the only thing I want to say is that, too, I studied economics, and as I said, I devoted my professional life to it because it's interesting and because there is a hell of a lot of market failures. If markets were working just as neatly as the Chicago School would claim they do, there would be nothing to study. So it would have been a very boring career. Instead, it's very interesting because there's lots of things happening out there. And everything, and I'm happy perhaps to settle here with the rest of the panel, in practice, given also constraints on the resources that the enforcers have, etc., and there is an asymmetry of resources out there that we need to agree on. I would be happy to settle on rebuttable structural presumptions, both for mergers and for some behaviors. Let's push it. Of course, now the question is, what is the right presumption? And so economics can be used to establish the right presumption. So that use of economics to get to that point, I think, is what I've been trying to do, with various degrees of success, let's put it that way. But this is where maybe we can settle in that direction, is a way forward. If it is instead doing other things at the margin, I think this is going to have an impact on our economies. What ultimately, and this is really my wish, as an Italian and British and European, I would like to have more competition, more innovation, more experimentation. I would like to have good jobs. I would like to have innovation which is done by European companies that remain European. Okay, they remain, and they have an opportunity to stay here. This is what I wish for our kids, because we are historical now. Thank you very much.
Now you can leave.
Thank you, Tommaso. If I may, if you have a minute, before again, my impression is that, which comes also from, is that the problem is that a certain stream of thought has made economics not an instrument, not a process, but an objective. And so the objective, say, of consumer welfare becomes the objective of competition law. While competition law has a different objective, which is the one which Professor Jossa recorded, which is to contribute to the objective of Article 3.3 of the European Union, which are the objectives that Tommaso was mentioning. So the economic, and therefore economics is very useful to ensure that a competition process, a competition model prevails in the economy, but through the organization of the analysis and therefore rebuttable presumptions and check on the rebuttable presumptions, therefore evolving our knowledge of how competition works, how the market is working. In this context, there's the problem that Maria Teresa was mentioning. That takes a lot of resources, and that's why we use short form like the guidelines on for instance, on 102 and so on. Excuse me for having interrupted the request for intervention. There's one there. No, prima, poi Fabrizio. Poi...
Well, my first question was for Tommaso, so he left, but I leave the question here. He mentioned that we need to introduce massive competition, innovation, and experimentation in Europe. I guess I would say that building or strengthening the single market will be certainly a way of doing it. I don't know if his answer will be that one. Maybe there are other answers. As far as methodology, economic methodology is concerned, I'm an economist, and I think it's a beautiful methodology. So much so that other, social sciences have learned a lot from economics, from game theory. As a methodology is a way of setting up the problem. Maybe, economics has gone too far in terms of modeling and all that, maybe. But the methodology is still here, and it's salvageable, and it's very useful. It's useful in competition, it's useful in regulation, it's useful in sociology, it's useful in political science, and all that. So, no, I mean, it's a wonderful methodology, has, decades of development, and it will still be here, and it will continue because it is useful.
Thank you. Okay, you want to...
Given that Tommaso is not here, I think that I'll take the challenge. First, to tell you that I am 100% with you. If we want more competition in Europe, I think that what we need to do is to accomplish the single market. The main sector in our economy is the service sector, and we don't have a single market there at all. And one could argue that the single market for products is also very inefficient with lots of barriers. But in services, which represents the bulk of our employment, we don't have a single market. And I would prefer to have a single market in many sectors with 6 European companies or 5 European companies than to have 100 telecom operators, all of them subscale. Our priority first is to ensure the single market, and then to ensure that there is competition within the single market.
May I say something on this? Yes, I totally agree with you. But then how do we deal with market concentration? Because I agree with you, and Mario Draghi in his report wrote that, we should support innovation, we should have big firms with a lot of capitals, and that's fine for me, but then I don't want to hear people complaining about market concentration then, and under enforcement of merger regulation.
So don't change anything until you have a single market. That's one option. The other option, and I think that we need to think seriously about that, and I don't have the answer, is, are we going to have cross-border mergers if we don't have first concentration at the national level or not? If the answer is yes, we can have cross-border mergers with the current degree of fragmentation, don't do anything. Now, we have seen not many cross-border mergers, and we have seen what politicians tend to do when anyone proposes a cross-border merger. Maybe the order of moves has to be the opposite.
Before giving the word to Enrico Fabrizi, but it really depends what the size of the market is, because 50 companies operating in 27 markets which are separated are much worse than 6 companies operating in the market which is a single market. The example of telecommunication is clear. I mean, since there is not a European market, in terms of single contracts, possibility of moving from one to another, to using the same contract in different countries and so on, we have 27 markets, and therefore we have 80 companies, because there's always a national one plus a number which do not, even Deutsche Telekom doesn't operate in all the 27 markets. It operates in 8 or 9, I think. So must be careful in making the comparison. I mean, this kind of comparison. The probably 5 companies in all of Europe in a single market would be even too many. In the US we have 3. Enrico, you were asking? No. Are there any other interventions or questions? Here's one. Excuse me, I was, okay. You were in the right place. I was, okay.
Yeah, thanks. I thought I'd take the opportunity to raise a question for you guys. On competition, there is this new competition tool that more and more member states have introduced. The UK have had it for a long time. The Commission hasn't been asking for it lately, at least, but I know Germany and Denmark and Norway have introduced this tool where competition authority can, do these market investigations and also by themselves, decide upon both structural and behavioral measures, which is something that is sort of forward-looking, looking to more or less design markets rather than punishing behavior in the past. So do you have any views on this trend that are going on in certain member states at least, while we heard that France is not wanting it, for instance? Thanks.
Well, as you know, as you probably remember, the Commission had proposed the new tool at the Commission level, but that was blocked politically, and the French view prevailed, and then you have switched away from antitrust into the regulatory saga of the MA, the SA, and so forth. So there was an attempt to have these at the Commission level, which I think, in line with what we were saying, was the right thing to do. Unfortunately, now we have, again, the opposite. We have Italy has also introduced these powers, which I think it's steps in the completely wrong direction. So now we have each member state which is restructuring its own market according to its logic, according to its, since it's a broad tool which does not have precise rules of application. As you know, you don't have to find a violation of the law. So again, highly discretionary. Again, you have room for political influence, for lobby, all the bad things I was talking about. So completely wrong approach. We should have added the new tool at the European level, not at each of the member state level. It's completely the opposite of what Europe needs.
And if I may add, I would add two things quickly. I'm not against the DMA or in favor of the DMA. I think that it has positive and negative aspects, although I think it's the result of trying to do something different, frankly, which was to have the market investigation tool. But if you think in terms of the needs of the European economy and of the European citizens, the effort that has gone into producing that regulatory framework, compare with the cost and the benefits, I think that it would have been very interesting to understand and do a cost-benefit analysis of putting the emphasis on the service directive and liberalizing services and generating a single market at the European level. I think that for Europeans, it would have been better that all that regulatory and political effort would have been placed there. And the second comment I wanted to say is that we have not mentioned state aid. But that is where I think that we really have a problem of under-enforcement, a serious problem of under-enforcement. And I am puzzled when I hear the European Commission saying, we are reluctant to consider investment commitments in the context of merger control, when at the same time they seem to be very willing to accept promises, not just commitments, promises when they approve a state aid here and there. And that state aid is another barrier to intra-European competition and is distorting the level playing field. So a little bit more consistency when we deal with the states as opposed to with the private parties would be, possibly a first-order effect on consumer welfare and all the other objectives of the 3.3.
I want to add 2 things. The new market tool is a very positive instrument as long as it brings you new knowledge as to about markets. and prevents you from stretching antitrust rules that should not be applied here and there just to grasp a conduct that otherwise could not be prosecuted. So on this side, the new competition tool is always good. Then I agree with their point of view. It's a tool of fragmentation right now. Yesterday we did a panel on the private enforcement of the DMA. That would be another big source of fragmentation around Europe. And in relation instead to the idea of working to create a better union, services on the one hand, capital markets on the other hand. The capital union, we desperately need one single market for capitals.
I don't see any hand raised. It's 6 o'clock, so I think it's time that we close this session. We close the festival, but if I understand, we have aperitifs afterwards, so that's good. And I thank very much Paolo. We have it, do we? I thank you very much, Paolo, and everybody else for allowing us to have this conference, this session, the FTIS conference, and thank you very much to all who have attended at this time. Thank you.
Okay, before you go, I think this was a terrific way to conclude our festival. You've done a wonderful job, and this was 100% expected, I have to say. The festival, I can say, went very well. I shouldn't be saying that, but I think so, and so I'll say it. And I say so also because I think that me personally is not the one to be praised for this success. I think this is due to the people that attended the festival, so I want to thank you for being here. It's due to the work that our partners have done to prepare all the parallel sessions, so thank you so much for contributing to the substance of the festival. And it's due to the very hard work that is done by my colleagues. So I think we all should thank them, and they are over there. Matilde, Benedetta, and of course you all know her, Silvia. Thank you so much for all your work. As I said on the first day, we know that we can do better, so we will keep going. So see you next year. Thank you so much.